I want to welcome everyone while folks are still joining. Thank you for taking time to join us for this presentation. And I really want to thank the MSBA Elder Law and Estates and Trust Law section for putting this presentation together. I know those of you who are following the listservs and probably amongst conversations with your colleagues have seen that there's a real hunger for information on the topics that we're going to be covering today. And so I really want to thank the Elder Law section and the Estates and Trust Law section for stepping up and putting this presentation together today. Danielle Cruttenden, the chair of the Estates and Trust Law section, is with us, as is Morris Klein, who is chair of the Elder Law section. And you're both familiar, or both sections are familiar with their contributions in past programming as faculty and program chairs and conveners of information and presentations. So Danielle, if you would like to introduce, as folks are still joining, we're up to 210 attendees, but Danielle, if you would like to go ahead and introduce your speakers to get our presentation started. Danielle, are you on? Well, I'll go ahead and introduce Kelly Pretorati with Baker Donaldson, who has prepared the first portion of our presentation on best practices for document execution and issues related to that, and the electronic notarization order that came from Governor Hogan this past week. So Kelly, if you're on, and if you could open your mic and go ahead and get started.
Thanks, Andrea. Hi, everybody. Can you hear me okay? See me okay? All right, I'm going to assume that's a yes. All right, so Elsa Smith, my colleague, estate planning colleague, is going to take the lead in walking us through what the requirements are for executing a valid will, trust, power of attorney, advanced medical directive, because that's the fundamental basis from which all this stems and all these issues surrounding social distancing arise. And then my role, just a little bit of background, I do fiduciary litigation as my whole practice. And so I want to talk about some of the issues that I've seen as arising in the context of the COVID-19 crisis and the creation of these instrumental documents for people facing all the challenges that we're facing right now. So Elsa, you want to start?
Hi, yes, good morning. Can everybody hear and see me? I know my camera. Okay.
We can.
Okay, excellent. Let's see. And okay. Well, good morning to all the 226 of you who are on the call. I should say good afternoon. Good afternoon, and thanks to the MSBA for the opportunity to participate in this webinar. As Kelly stated, I'm going to lay the foundation, and then she's going to follow up with issues that may arise given this COVID-19 environment. Now, although it's the practice of many attorneys to have a formal execution process for estate planning documents with the testator and two unrelated witnesses in the same room, before we discuss executing documents in today's COVID-19 environment, I want to cover what the rules are for valid execution of estate planning documents. So here's the roadmap. We'll cover the requirements for valid execution of wills, revocable trust, powers of attorney, and advanced medical directives, including oral medical directives. Here we go. So the execution requirements for a will in Maryland. And for those of you taking notes, I try to outline as I go to help you in your note taking. So we're looking at Estates and Trust Code section 4102, and the requirements, as most of you who are watching know, that every...
I will let Barrett know. Thank
that every will shall be in writing, signed by the testator or by some other person for him or her, and I'll just use his for purposes of this video, just for convenience sake, in his presence and by his express direction. And 3, attested and signed by 2 or more credible witness in the presence of the testator. So let's break down this section and discuss what this means in practical terms. And I'm going to touch on 6 points. First, now, who can serve as a witness? Now, that's anyone who is competent and of the age of majority can serve as a witness. And also under Maryland law, beneficiaries and personal representatives are not prohibited from serving as witnesses. Point number 2, what is a credible witness? And that applies to a witness who is competent at the time of attestation. Point number 3, witnesses do not have to know what is being signed, nor do they have to review a copy of the rest of the document other than the signature lines and the attestation clause. Point 4, the witnesses to a will must be in the testator's presence. Witnesses cannot observe through audio-visual technology, much like you and I are seeing each other right now. In other words, there's no remote or virtual witnessing as of right now. No remote or virtual witnessing is allowed under current Maryland law. Now, presence. Other than the prohibition on using audio-visual technology isn't defined under recorded case law, but it generally follows one of 2 tests, and that's the line of vision or line of sight test and the conscious presence test. If the testator can see the witnesses sign and are aware of their presence without the benefit of audio-visual technology, then it's safe to say that the witnesses are in the presence of the testator. 5th point, witnesses don't need to sign at the same time as one another, so long as they each sign in the presence of the testator. And just a practice note, if you don't know if the witnesses will be signing in each other's presence, just make sure that the attestation clause reflects this. Now, while the testator generally signs first, the testator doesn't have to sign in the presence of the witnesses. However, the witnesses must sign in the presence of the testator. Let me give you an example. The testator can sign alone. Then the first witness can sign in the presence of the testator, and then the second witness could later sign in the presence of the testator. And here's the last point, the 6th point. A proper attestation in Maryland does not require the witnesses to sign on the same page as the testator or on physically connected pages. But the pages of the will should be numbered and have the same, font and look as the rest of the document. And for those,
and Elsa, real quick, because I'm keeping an eye on these chat questions as they come up, and I know it's hard for you to do it, but someone had raised a question as to whether you could witness a will remotely, and the answer to that, as of the law stands right now, is no. So the remote notarization order and current law do not alleviate the requirement that 2 witnesses sign in the presence of a testator, correct?
Correct. That's correct. And thank you so much for fielding that, because you're right.
And one other point, someone had asked whether there should be slides. There are not slides to this portion of the presentation.
That's correct. There are not slides, and I'm trying to, that's why I try to give a roadmap as to what I'm going to talk about, just to make it easy for those of you who are taking notes and are being active listeners, and I appreciate you. Okay, next section. As I said in my roadmap, now we're going to talk about the execution requirements for a revocable trust in Maryland. And this is going to be a really short section because there are no formal requirements for an execution of a trust, except the only requirement is that the settlor has to indicate the intention to create a trust. Now, under the Maryland Trust Act, a trust can even be created by an oral statement. But the creation of the trust and the terms of the oral trust can be established only by clear and convincing evidence. Let's see, establishing a trust, as you saw, requires fewer formalities than executing a will. So now we're going to move on to a durable power of attorney and the execution requirements for that. So we're looking at Estates and Trusts section 17.110. The requirements are that one, the POA or the power of attorney has to be in writing. Number two, signed by the principal or by some other person for the principal, in the presence of the principal, and act the express direction of the principal. Acknowledged by the principal before a notary public, and for attested and signed by 2 or more adult witnesses who sign in the presence of the principal and in the presence of each other. Now, okay, let me stop right here. This is different than the requirements for a will. The witnesses must be in the presence of each other when they sign the power of attorney. Okay. And under Part B of this same code section, it states that the notary public can serve as one or two, or as one of the 2 adult witnesses. Now, asterisk. There's an act passed in 2019 which is scheduled to take effect this year, October 1 of this year. And for those of you taking notes, that's SB 678, Chapter 407. And it says that notaries are permitted to acknowledge powers of attorney remotely, but cannot serve as one of the witnesses if they do so. Now, I urge you to take urge you to take a look at, there was an update issued this morning by our own Richard Montgomery. It's on the MSBA website. That speaks to this. So after the webinar, I encourage you to do so. Take a look at that. There was legislation passed but not signed during the 2020 legislative session, which attempted to delay the effective date until 2021. But again, as of right now, the effective date of that law is October 1st, 2020. And as
just a quick question for you, Elsa, because
sure.
I think the thing that's top of mind for people when we're dealing with notarizations, there is the order from the governor you're going to get there. Okay.
I'm going to jump into it right now. So effective March 30th, Governor Hogan signed an executive order that the in-person requirement for notarizing documents is temporarily waived for the duration of the COVID-19 emergency, subject to guidance provided by the Secretary of State. For those of you who want to read the contents of the order, there is a link on the MSBA website. And just so you know, the contents of the emergency order are temporary guidelines that apply during this emergency. And it's a waiver of the in-person requirement during the term of this emergency. Now, all other requirements for forming notary acts are in full force and effect. Let's see. Now we're going to get into a lot more about remote notaries during Kelly's presentation. So I know a lot of you are interested, and I know there's a lot of chat on it. So just have a little patience. We'll get to at least some of your questions. So now we're going to move on to the requirements, the execution requirements for advanced medical directives in Maryland. And under this heading, there are 4 points. Now we're looking at Maryland Code Health General Section 5602. All right, so we know that an advanced medical directive can be written or an electronic document that is dated, signed by or at the express direction of the declarant, and subscribed by 2 competent witnesses. The healthcare agent can't be a witness, and at least one of the witnesses must be an individual who is not knowingly entitled to any portion of the estate of the declarant or knowingly entitled to any financial benefit by reason of the death of the declarant. Point number 2, the directive, advanced medical directive, may be signed, electronically, both by the declarant and the witnesses. However, for those signatures to have the same effect as manual signatures, they have to comply with the requirements of 5601.1. And that includes that the electronic signature is unique to the individual using it, and it's under the individual's sole control, and it uses an algorithm approved by the National Institute of Standards and Technology. Point number 3, an advanced directive can also be an electronic document without any witnesses at all, and this is for your reference under 5602C3. And it provided that the declarant's identity has been authenticated in accordance with standards set forth in a special publication 800-63-2 or a replacement guideline issued by the National Institute of Standards and Technology. While these standards are also the same standards mentioned, as I said before, in 5601.1, the reference to quote-unquote special publication, it suggests that there's a possibility that that publication may have a higher standard of authentication. So you're encouraged to take a look at that. And the last point, an advanced medical directive, an electronic one that is, that's made in accordance with 5602C3 and is required by Health General 562.3C2, has to be submitted to an electronic advanced directive service recognized by the Maryland Healthcare Commission. Now, so far there's only one company authorized to process these electronic advanced directives, and you can get more information on that on the Maryland Healthcare Commission's website. So, does this mean that I can make my own electronic advanced medical directives for my clients? No. The process for electronic signatures has to comply with all of the requirements of 5601.1. As I mentioned, including meeting the standards of the National Institutes of Standards and Technology. Now, hospitals and healthcare professionals with the systems in place that comply with all of these standards, they're likely to be the best resource for our clients to use electronic advanced medical directives. And the last section we're going to talk about is oral advanced directives. And now we're looking at Health General 5602 for your reference. An advanced medical directive can also be witnessed by an oral statement. Any competent individual can make an oral advanced directive to authorize the providing, withholding, or withdrawing of any life-sustaining procedure, or to appoint an agent to make healthcare decisions for that individual. An oral advanced directive has the same effect as a written or electronic advanced directive if made in the presence of an attending physician, physician assistant, or nurse practitioner and one witness. And if the substance of the oral advanced directive is documented as part of the, and if the substance of the oral advanced directive is documented as part of the individual's medical record, that documentation should be dated and signed, shall be dated and signed by the attending physician, physician assistant, or nurse practitioner and the witness. So there we go. I've given you what the law is at present regarding wills, revocable trusts, durable powers of attorney, and advanced medical directives. Now that lays the foundation for the next presentation that we're going to have from Kelly, where she touches on potential areas of litigation, especially viewing it through the lens of this COVID-19 state of emergency. So I'm going to now hand it over to Kelly.
Thanks, Elsa. Can you hear me?
I sure can.
Okay, great.
And I'm going to mute myself, I think. Let's see.
All right, so first and foremost, I don't purport to be an expert on remote notarization. So I'm gonna weave that into this as far as I have reviewed the statute that is to be implemented, and then the governor's recent order. But I do think that we are going to have further webinar seminars available, specifically dealing with remote notarization. So let's talk first about wills and the issues that can arise in this COVID environment. I think all of you have seen on the listserv that there's a lot of questions about how to get documents properly signed and properly witnessed in light of the social distancing measures. And there are a lot of different approaches people have employed, like seeking to have clients drive through, sending letters to your clients with detailed instructions surrounding how to properly execute your documents. And all of those are good options in this environment that we find ourselves in. I think that you have to do what works for you in your practice, and you have to know your clients. And one of the biggest issues I see from a litigation standpoint when it comes to the execution of wills in this environment is the fact that we may feel rushed to do documents for people that we maybe don't have a long history of interaction with. And the fact that we are being pushed to move quickly may result in poor documentation of your file as to the proper execution of the document, and may also result in a failure to properly identify issues associated with undue influence and capacity, all of which are bases for invalidating a will. So I think people could attack them on the basis of not properly being executed, taking issue with whether the witnesses were actually where they needed to be when they executed the documents. And so as practitioners, it's probably a good practice to continue to do memos to the file describing the nature of the execution, whether it be drive-through and you have witnesses coming and going and stepping out in a 6-foot range, or if you're doing executions in conference rooms where you have people looking at the testator signing and the testator looking at the witnesses signing through the glass in order to try and keep their distance from one another. One of the things that I thought about when I was talking with a friend and colleague yesterday was sort of like the snowball effect of how this could play out, and how we as lawyers need to think proactively how to protect our clients and also how to protect ourselves in this environment. So first and foremost, bringing people to the office to sign. I know that many of us feel that we need to watch our clients do this to make sure it's done effectively. And we've all experienced times when you send the packets to the clients and something is missed. And so you have to sort of balance the sort of risk health benefit analysis to having clients coming to your office. But the snowball effect that I was just mentioning is the concern that you tell a client they need to come to your office in order for you to make sure that they do this correctly. And then in doing that, maybe you had an elderly person who had been self-isolating for a significant period of time and had not otherwise been exposed to the external environment. They come to your office, they go home, and they contract COVID. And there's no real way to connect it to your office, but that's the only place that they've been. And they sadly pass away, and their family files a lawsuit. I know that seems crazy and maybe a little attenuated, but believe me, as a litigator, I've seen it all. Well, I've seen a lot. I haven't seen it all. And I could see something like that happening. So in order as lawyers to best protect ourselves and our clients, a couple options would be to have the client stay home and execute all their documents at home. and that you send them a letter, a detailed letter telling them how to do it. But in conjunction with that, if you can get someone who is technologically savvy and can be with the client and loop you in via Zoom, you as the attorney can watch everything that's going on, see each document as it's executed, make sure that it's done effectively, and look at it through that way without having direct interaction with your client. I think that might be a good solution if you are really nervous that documents aren't going to be done well. Additionally, you can have clients sign documents at home and then have them scan copies to you so that you can quickly review them and to make sure that they were done effectively. But going back to the example of the lawsuit, it might not be a bad idea in this environment to add a little language to your engagement letter that acknowledges that we are in a health crisis, that COVID is very contagious, that our recommendation is that everybody stay home, and to the extent clients decide to come to your office to execute documents, they are assuming the risk and agreeing to hold your firm harmless. Similarly, we talked about the issues associated with vetting out new clients and familial issues that can be embedded in those relationships. I'm going to say wholeheartedly that we need to continue to do that. And as a litigator, oftentimes I look at facts on the circumstances surrounding what prompted the new execution of the document. And if you have a healthcare provider like an in-home nurse bringing an elderly client to do a new will, for me, that would be a red flag, and try to understand what's the nature behind the new document being prepared. Maybe it's a first document. Did they have a prior lawyer? Certainly get a sense of their family tree. Is this nurse somehow benefiting from the will? I hate to say it, but in a environment like this that we find ourselves in, there are always going to be people who take advantage of it. And there's no more vulnerable population right now than the elderly. And we also need to be looking at capacity issues, cognition, and all those issues that play into whether someone can effectively execute a new will, power of attorney, advanced medical directive, or a trust. Let's see, I also pointed out that there are many of the, I think all of the nursing homes are locked down, and so those can present additional issues with people who otherwise would like to have documents done, maybe not being able to get them done, and Zoom is probably very difficult to use there. Just to be clear about the Zoom option, it is a way to meet with clients, it is a way to interact with clients, it is not a way to witness anything at this point. Although I have heard that there is a big push during this crisis to have the option of a remote witness, we have not seen any order to that effect yet. So as things stand right now, if witnesses need to sign a document, they need to be present. The remote notarization order that we received from the governor on March 30th, I'll just touch upon it. It stands on its own. So although there is new legislation coming into play October of 2020, in order to effectively comply with a remote notarization as it's permitted right now, you need to read the governor's order in isolation. I've seen some discussion on the listserv about whether wills are specifically excluded under the governor's order, and they are not. And wills don't need to be notarized in Maryland, but perhaps you are seeking notarization of a will to have it be effective in another state that would require a notarization. And so just know that you need to file with the requirements of the remote notarization order, which are very specific in terms of registration, using authorized technology services to perform the remote aspect of the notarization, how much you can charge for it. So again, going back to the Zoom issue that has come up, Zoom is not a way to remote notarize any document. It needs to be through the technology services that are specifically set up in order to provide remote notarization. And I have seen a lot of activity on the listserv about naming all those entities, and I do think there's some effort to get clear on which are approved, which are appropriate under the order and which are not. And I think that's a work in progress. So at this point, we built in some time for questions because the idea was this was going to be more of a town hall presentation. I'm going to start looking at the chat list and see if we can answer some questions. And Elsa, why don't I just go through it, and if it looks like a question that's appropriate for me, I'll answer it. And if it looks like it's a question appropriate for you, I'll turn it over to you. Does that make sense?
That sounds fine. I just unmuted myself. So let me, just so that there's not any echo, let me mute myself until I deem it appropriate.
Okay, so I saw a question around 1:10 p.m. asking if witnesses can or cannot witness virtually. They cannot. Until an order comes from the governor that says otherwise, witnesses are not permitted to witness documents remotely through Zoom or otherwise. There needs to be a line of sight. Let's see, must trusts be notarized? The answer to that is no, and Elsa touched on that. There are very few requirements for the creation of a valid trust other than intention. But that said, often practitioners like to notarize documents for a whole host of different reasons. So Elsa, there wouldn't be no problem with notarizing a trust or a will, correct?
That's correct.
But that would be to you as the practitioner in your discretion.
That's correct.
And this is one I'll flip to you, and I don't know if you'll know the answer off the top of your head, but we received a question asking whether there is case law that the testator's signature must be on the same page as the witness's signature. And the person who asked the question mentions the Castruccio case, mentioning something of that effect.
I just had to unmute myself. That's correct. Right. The site for that is 456 Maryland 1, 169 A3rd 431. That's a 2017 case, Castruccio versus the state of Castruccio.
Okay. Let's see. A lot of people said that they were having trouble with the sound, so hopefully that's resolved. Let's see.
I'm going to go back to muting myself.
Okay. Someone was pointing out that Zoom will record, but you need to get permission from all people on the Zoom to be recorded. That raises another issue that really comes up in any COVID, non-COVID environment about whether to record the execution of a will. And we were talking about this yesterday a little bit in preparation for this presentation. And I think estate planning practitioners may have differing views than litigators on this point. So I'll give you my perspective and then Elsa can give you hers. From my perspective, it is evidence, good or bad. So if you are going to record the execution of any instrument, whether it be a will or other estate planning document, you better be very sure that it's going to go well. And so to that point, I recommend that if you are going to go through the steps of executing a will and try and establish that people are doing it of their own free will or that they have capacity to make the instrument, it might be prudent to do a dry run, because once the document or the recording rather exists, it should exist forever. Otherwise, you are destroying evidence and an adverse inference could be drawn against you in the context of litigation. So just give thought to that before you decide to record a signing of any sort. Elsa, do you have any additional thoughts?
No, I concur 100% with that. It's a double-edged sword.
Yeah, and then another question was posed. Does remote notarization mean done electronically? It does not. The remote notarization order, as I read it, and Elsa, tell me if you have a different point of view, means that people can authenticate that other people are who they say they are through an audio and video mechanism. as opposed to being there in person. But the notary actually signs their notarization, and the person signing the document signs their document, so there are no electronic signatures involved.
That's my understanding as well.
All right. And then I saw another commenter say Zoom can record notarization. I'd like to see an explanation for why this is not sufficient. I think that there are specific services that have been created in order to provide remote notarization, and Zoom, as I understand it right now, is not one of them. It would just be, I mean, similar to using FaceTime and saying that if FaceTime, if we can record and we get everybody's permission to record, is that sufficient to meet the parameters of the governor's order? And I'm not sure that it is at this point. Let's see. This is a question for you, Elsa, and I think it relates to the advanced medical directive. Does an oral advanced medical directive trump a prior written one?
Had to unmute myself. I'm going to say that it may, as long as it's in that it conforms to Health General 5602 and all of those requirements. I don't see why not. Do you have a different take on that, Kelly? Or
now, I agree with you. I think that if it's done, if the oral advanced medical directive is done correctly, it has the same effect as a written one and would take precedent. All right. Another question. It says wills can be remotely notarized? Question mark. I thought by the SOS making reference to the new law taking effect on 1/1/20, which does not allow remote notarization of wills. Wills are not permitted to be notarized remotely. I read that differently. I think that the governor's order stands on its own. And so if you choose to notarize your wills, it appears to me that per the governor's order, you could do so remotely if you meet the requirements of the governor's order. But maybe it's ambiguous, and maybe I'm wrong. Elsa, do you have a point of view on that?
I agree with you. The law, the 2019 law, it doesn't take effect. It's not scheduled to take effect until 10/1/2020. So right now, what we have to hang our hat on, so to speak, is the governor's executive order. I believe you just have to take it at as it reads at face value. Yeah, and otherwise, I concur with you, Kelly.
And we may get greater clarity from the governor's office on how this is supposed to be implemented. And I do, like I mentioned before, think a lot of people are interested in seeing this expanded to allow for remote witnessing to take place, because frankly, it's a difficult scenario you find yourself in when you're trying to get documents executed and to implement strict social distancing measures. Let's see, I think we have about 5 more minutes. So here's a question for you, Elsa. Can testator sign in presence of witness 1, then later witness 2 signs the will already signed by testator and witness 1? i.e. witness 2 doesn't need to see the testator sign.
Are we, okay. Oops.
I can look at the question at 134, but I think that the answer to that is that I think the answer to that is that witness 2 does not need to see the testator sign, but the testator needs to see the witness sign. Let's see, for statutory POA that requires a notary, is any of it valid without a notary? I think that if a notary is required, then a notary is required. Can you see these chat messages, Elsa?
Okay, let me toggle on to, okay, there, I think I see some of them. And no, as long as, yeah, as long as the, oops, can you hear me right now?
Yes.
Okay. Okay. Yeah, no, a notary is, it's explicitly required. So, you know, there's no way to get around that, in my opinion.
In remote notarization, does the client return the documents to the notary for a written signature by notary, or can notary sign electronically? So I don't know in reality how this plays out, because I haven't tried to have any documents remotely notarized. And I was talking with a friend yesterday, and she is about to do it, so I'm hoping to learn from her. But it was my impression that the remote notary signature was a live signature, and that the person's signature being notarized is a live signature, and then the documents are sent so that they can be compiled together.
Yeah, I haven't done one. I haven't done one either. So I'm anxiously waiting to see what the experience of others are, of doing that.
And I have a feeling that there will be people who are trying that this week. And so maybe next week or the week after, there can be a subsequent video town hall similar to this, where we focus just on the ins and outs and use of remote notarization.
Kelly, did we want to touch on some of the practice ideas that we talked about offline, or do we
Yeah, I
want to
think that's
leave
a good
that?
idea. Why don't
Yeah.
we use the rest of our time just to walk through some suggestions on how to carry out the execution of documents in this social distancing world in which we find ourselves?
Agreed. Well, I'll take, and I'm referring to the list of suggestions.
Yeah, do you want me to go through them, or are you going to go through them?
We only have about another minute, so.
Okay, how about we do this then? Maybe if we're permitted, we'll post some suggestions on MSBA's website on how to effectively carry out signing of documents in a social distancing environment. And just so anyone who's on the call knows, you're welcome to email me with any questions at any time. Like I said, I'm wading through this just like you guys are, and many of you are better versed in the actual execution of documents, but I'm happy to respond to any questions you might have about litigation-focused issues. And Elsa, you have anything else to add before we sign off?
Sure, I'd be available to answer any questions offline of the ideas for document execution that we discussed offline. They're pretty creative, and I, for one, reached out to practitioners in other states, again, because everybody is going through the same thing. And they're pretty, as attorneys, we're a pretty resourceful bunch, so we'll make sure and put all these suggestions, and that indeed is what they are. These are suggestions. We're not dictating that this is the way that you ought to try to execute documents. So I just want to make that clear.
Okay, well, thank you both for presenting today. And we have Morris Klein, the chair of the Elder Law section, who's going to introduce his speakers in just a moment. And we will, Elsa and Kelly, collect the questions and forward them to your attention that didn't get answered, and share them out on our COVID-19 MSBA resource page. So thank you. And Morris, if you could introduce your speakers, please.
Sure. Hi, I'm Morris Klein. I am the chair of the Elder Law section. I want to thank Andrea and Danielle for working collaboratively in putting this together on short notice. We're going to have two speakers. We're first going to have Megan Rusciano, who's a staff attorney for the Disability Rights of Maryland, formerly known as the Maryland Disability Law Center, who will speak about patient rights and meeting with patients in this era of COVID. And then after her, we're going to have Lori Mayorga speak, who is the Deputy Director of Eligibility Policy at the Maryland Department of Health and she is going to talk about some of the changes relating to Medicaid in this new era. But before I do that, I want to take 30 seconds to mention something that I realize should be covered that isn't being covered, which is eligibility for nursing home skilled care under Medicare Part A. CMS recently issued some emergency regulations that will allow Medicare coverage for SNFs without a 3-day inpatient stay for beneficiaries who have experienced dislocations or are otherwise affected by this health emergency, who are evacuated from a nursing home in the emergency area, who are discharged from a hospital in order to make room for more seriously ill patients, or need SNFs care as a result of the emergency, regardless of whether they were in a hospital or nursing home prior to the emergency. Similarly, CMS will provide beneficiaries renewed coverage for extended care services which do not require a new spell of illness. This will be available for persons who need care as a result of the emergency. It's only for beneficiaries who have been delayed or prevented by the emergency from commencing or completing their needs for skilled care. So with that, I'm going to turn it over to Megan.
Can everybody hear me? I'll take that as a yes.
We can hear you. It's a little soft.
Awesome. Wonderful. All right, so I am going to present to everybody really quickly on just some issues surrounding client rights during the pandemic. I am from Disability Rights Maryland. As Morris pointed out, we are Maryland's federally designated protection and advocacy agency, federally required to protect and advance the rights of people with disabilities. So next slide, is it all possible? Thanks. This is just the typical disclaimer. The one thing just to note is this situation, as we all know, is changing by the day. And so some of the information and links that I provide in these slides may become outdated. I ask you just to try to keep up to date as much as you can. So next slide. So just an overview of what I'm going to cover briefly, talk a little bit about right to equal treatment and care, some issues that we have been seeing across the country around that. Probably the meat of the presentation is the second point on right to visitation and how that's working right now in different settings. Third, reporting rights violations. So if you hear of rights violations, how do you ensure that they're reported and investigated? And then part 4, I have some resources for you as well. So next slide. Possible to move to the next slide?
Bear with me, my computer froze, of course. So.
Totally, no worries. I can continue in the interest of time if that's helpful, because I want to make sure that we can get to questions. So regarding the,
But keep going.
Keep going. So right now I'll move to slide 5, Bill. So the right to equal treatment and care, what we have been seeing across the country is a threat really of rationing care to people with disabilities, people with pre-existing conditions. So basically states have created different plans in which they've said, basically outlined who will receive life-sustaining treatment and who won't, and what factors, including age, health, and likelihood of survival, will dictate that. Bill, if you want to move on to the next slide, I think it should be there. There we go. So this is a problem that we've been seeing across the country, and advocates in a handful of states have actually filed complaints with the Office of Civil Rights, basically citing violations of the ADA, Section 504 of the Rehab Act, and the Affordable Care Act, and they were supported by various national organizations, including the National Council on Disability, and OCR issued guidance in response. You can move to the next slide, Bill. Awesome. So basically, OAR found that people with disabilities should not be denied medical care based on stereotypes, assessments of their quality of life, or determinations about a person's relative worth based on the presence or absence of disability. What we're really concerned about here is people making judgments based on what they assume or presume is the value, quote unquote, of a person's life, if they have pre-existing conditions or if they have a disability. OCR is requiring that decisions by covered entities concerning whether the person actually should be receiving treatment needs to be based on individualized assessment of the best available objective medical evidence. So we're in the process of interpreting what that is and where we are. So if you want to move on to the next slide. So protection and advocacy systems across the country have been trying to kind of outline some guidance and write to governors and put out more information on what guidelines states should be using. Mostly some examples include not making quality of life judgments, recognizing that a person's qualified to receive COVID-19 treatment if they can benefit from it and it's not contraindicated, and providing reasonable accommodations where to ensure that healthcare is effective and ensure effective communication. So if you all in the course of your work happen to hear of any of these things, please let us know. This is a big concern that we're having, and other states have put out these plans, and we just want to ensure that people, continue to have equal access to the treatment that they need. So next slide is the right to visitation, kind of the meat of everything. We can move on to the next slide. So nursing homes, I'm going to kind of break this out over different areas. Nursing homes per MDH are restricted. All visitors are restricted except for extenuating circumstances. Of course, extenuating circumstances isn't defined. There are exceptions carved out for healthcare workers and surveyors. Reports are that interpretation of this varies greatly depending on the facility. So if you're probably looking at a rural facility with few cases, you might have more luck and a broader, broader inclusion than if you're certainly at some place like Pleasant View right now. You're not going to be able to get in. Centers for Medicare and Medicaid CMS in their guidance indicated that visits should only be for compassionate care, with again the similar exceptions for healthcare workers and surveyors. There's really no guidance on what compassionate care is aside from end-of-life decisions. That I've heard reports has been considered broader than hospice, but again, it's unclear, and the reports that we're hearing on the ground from folks across the state is it's really varying facility by facility. One thing just to note is the distinction in the guidance from NDH, it's extenuating circumstances, from CMS, it's compassionate care. You might be able to squeak out more in extenuating circumstances, but like I said, it's really going to vary facility by facility. Assisted living facilities have the same guidance as nursing homes, so they will be subject to these same restrictions. I'm going to move on to the next slide, if possible. So as far as visitation of folks in DDA facilities or group homes, MDH had some guidance on small congregate facilities indicating that they may allow visitors with substantial precautions and monitoring them for symptoms. But then just yesterday, DDA issued guidance temporarily suspending visits from family, friends, and others unless they're considered essential visits and essential people. So access to DDA facilities is very, very limited at this time. And updates from DDA are available on their website. But just like with nursing homes and assisted living facilities, it's going to vary based on where you are. Next slide. Even if visitors are permitted, the facility may turn away visitors if they're exhibiting any symptoms of COVID-19, require certain precautions, including taking temperatures, monitoring for symptoms, wearing protective gear. And per CMS guidelines, states are allowed to enact more restrictive policies than what CMS promulgates. So you could be looking at something that's a lot more restrictive. We as advocates need to think creatively about how we're interacting with clients at this time, especially clients who are vulnerable to COVID-19, if they're elderly, if they have pre-existing conditions. Use of phones and mail, coordination with family members where family member has authority, and you're able to do that. Some states have carved out exceptions for protection and advocacy agencies, allowing us to go in. We're still working on that here in Maryland. But really, ultimately, it's coming down to making determinations of if you're trying to get documents signed, how that's happening, because you're not likely going to be able to get in, or you really aren't going to be able to get in these circumstances. And also just being generally aware, if people are more vulnerable to COVID-19, do you, as someone who may be asymptomatic or not a carrier, do you want to introduce them to that? So just thinking questions around liability. Next slide. So reporting rights violations, and next slide again, if it's possible. Great, so what do you do? I'm going to have to. I'm sorry. So as far as just if there are rights violations and what's happening, patient bill of rights, it clearly still holds the assisted living facilities, long-term care facilities, and the patient bill of rights in hospitals that was signed into law last year still applies. The state ombudsman continue to monitor and investigate instances of abuse and neglect and complaints. They are still, proceeding and doing what they can to investigate these situations remotely. They aren't going out in person, clearly, at this time. The Office of Healthcare Quality will investigate reports of abuse and neglect as well, and will actually do in-person visits. It's my understanding right now that they will still do in-person visits if there's an imminent risk. So they are one of the few folks who are being allowed in at this time if there is an imminent risk. So if you hear of anything going on, that may rise to that level, of course it's undefined, you can refer to them to potentially investigate. Next slide. It's just resources, and I'll move on to the next slide after that. So just some resources to consider. There's an upcoming webinar tomorrow, actually, from Justice and Aging on nursing facilities and assisted living during COVID-19 emergency. I've included the registration link there. I think it's, Justice and Aging has done a number of webinars. They've been helpful. Reporting abuse, contact the state ombudsman for clearly any complaints. Office of Healthcare Quality, as I mentioned, is going out and doing reports, and so are we at Disability Rights Maryland. And then I've just included some links for people with disabilities on COVID-19 if you're looking to explain it to somebody who may have some cognitive delays or concerns. There are some great resources out there about explaining it to folks. So that's it for me, and I will take questions at the end after Lori goes ahead now.
Thanks, Bill. Can everyone hear me? Can anyone hear me?
Yes, we can hear you.
Awesome. Okay. Old laptop. I am, as you know, not the master of slides, but I have done my best to rise to the occasion. If you can imagine that Medicaid is just racing around with its many heads, talking to the many heads of CMS to arrange all the kinds of flexibilities that are available under various different legal authorities to allow us to cope with the new situation. So can we go to the next slide, please? So I gave you a picture of our little Office of Long-Term Services and Supports memo because it's already been overtaken by events. So here's kind of the most important issue. This was primarily announcing that we're allowed to extend redeterminations. Those that were going to be coming due at the end of March did not result in people losing coverage, and the same is going to be true for April. We can go to the next slide where it actually, oops, I think I'm backwards. Next slide, please. Sorry. So there we go. This explains, that everything has been pushed back up to May 31st, and for these 2 months, March and April, obviously we're going to have to continue making adjustments as the situation develops. The next slide, please. Thanks. The extension does not yet address new applications, initial applications, and having more time before the timely processing deadline causes them to close. For some reason, CMS is really kind of taking a long time to respond to this, but we are assuming that this authority is going to be forthcoming. It's not very helpful, and we're hoping that additional flexibility will become available. The bottom of the slide is the most important thing. What we received instructions from CMS on, I think they issued some additional FAQs on Tuesday, the 24th, explaining what states have to do in order to qualify for enhanced federal match during this period. So you can imagine that this is something states are going to do, including ours. We're not supposed to terminate Medicaid coverage for anyone who is enrolled at the time of the crisis start, the emergency beginning, which was March 18th, or who become eligible during it after March 18th and while it's still going on, unless the person wants to get out or they leave the state. And in federal speak, that includes dying. A dead person is considered no longer residing in the state, and they're allowed to be terminated. So you can see we have to do a lot of system work to deal with the automated terminations on the community magi side, but I think that we've already communicated with the caseworkers for the long-term care and ABD side, in which case most of those actions require an individual caseworker pushing the button, so we can just have them desist in order to avoid having anyone terminated when they really need continued medical assistance the most. So on to the next page, slide, whatever it's called. Thank you. Maryland Department of Health has changed its homepage for medical assistance to incorporate notices to providers and notices to participants. And the idea is that since we're getting the answers to our questions in this spotty way, we're going to keep adding to those areas, and you can check them from time to time to see what's happening. I noticed that that memo that I showed you the picture of has not been posted to the website, which suggests to me that it's been overtaken by events and there's going to be a further update to that update, which will then be posted. If you go to the next page, I've given you images of here. This is the link to it's the same link, and this is the next page is, sorry, Bill. The next is images that you would click on. They've got beautiful pictures of the COVID ID virus element. There's one for providers and there's one for participants. And we're hoping that we'll be able to have much more detail. There are lots of areas of change that we're in discussion about, and we're hearing about them very sporadically, and we're trying to push this information out to the people who need it as quickly as we can. And that's about it for me. I'm short on time, but I yield to questions.
Hey, Lori, I have a question. Do you mind if I share the slides with the participants?
Oh, please do.
Lori, there was one question that I saw came in asking about dropping off applications at local DSS offices or otherwise submitting applications to local DSS offices.
Well, when we spoke to DHS last week, we were trying to get out a joint transmittal with them, which didn't happen. They were saying that although the DSS offices have been theoretically closed to the public, that they are still allowing access to the drop boxes. So, and behind the scenes, the workers, at least as of last week, were still reporting to the offices because the capacity of DHS to have remote or teleworking employees is very limited. So they're still having people in the LDSS doing the case processing. That's what I know as of this moment. And of course, that's always going to be subject to update. So if you find out that you can't drop things off in the customary way, please, contact me right away. My email address is up there, and I still respond to emails, and I still take forever to respond to the phone. So I didn't give you the number.
I'm not aware of any other questions that have come in. Oh, here's a question. Can continuing care retirement communities prohibit independent living residents from receiving visitors? If so, can they discriminate, allow some independent living residents to receive visitors and prohibit others? Megan, I think that's your area.
Sure. So I would have to refer that. If you want to contact our office offline, we're kind of trying to figure out different access authority as people, as things are unfolding. Right now, the CMS guidance is just clearly for long-term care facilities. I'm not aware of, these senior living having any other guidance. We are getting reports that people are restricting, different agencies are restricting just access based on safety. But I would encourage you to contact me. My information's in the slides. Please do, and I'll see if there's more that we can do to find out about that.
All right. Well, I don't see any additional questions. So, Andrea, I'm going to return the program back to you.
Okay. Thank you, Morris, and thank you, Megan, and thank you, Lori, and Elsa and Kelly, and everybody who contributed as presenters today, and Morris and Danielle, thank you for recruiting your section practitioner community can benefit from the knowledge and have this forum to exchange ideas. Let's see, I think that one more question came in. Will remote PT visits? No, that's not a complete question. Okay. So if anybody wants to, we will save the questions in the chat line and forward them to faculty. And if there are any that did not get answered, we will share that out to the registrants. We do have email addresses. And thank you all for taking the time to join us today. And we wish you the best. Take care.
Andrea?
Bye-bye.
Andrea?
Wait.
Yes?
Is everyone there? Richard Montgomery here. Can anyone hear me?
Yeah.
Yes.
Okay. There were a couple of things that I just wanted to throw in. I know the most baffling thing about remote notarization is any sort of explanation on the mechanics of this. I spoke with an employee who I don't know who they were about this in the Secretary of State's office the other day. And there were a couple of things that they threw out. One is that every component of the notarization has to happen at one time in one electronic session. That there are not to be any mailing or emailing of documents, and that the notary must be able to affix their seal electronically, and the final requirement is that the document must be securely storable for 10 years. There was one other thing that I wanted to touch on that someone had asked about, and that was advocacy on the issue of remote witnessing. That's something that's really on our front burner in terms of advocacy at the MSBA. We're going to be having a meeting or two this afternoon about that. This is a little bit different politically and legally than the remote notarization, because as Elsa mentioned earlier, the General Assembly had passed a bill that was an adaptation of the Remote Uniform Law on Notarial Acts in 2019 that unfortunately had a delayed effective date until October 1st. The executive order had the effect of basically providing a bridge to allow remote notarization now. In the same General Assembly session in 2019, that was when the General Assembly expressly prohibited remote witnessing of wills. So that provides a higher hurdle for a governor to get over in terms of unilateral action. Now, we had heard that there was going to be a special session of the General Assembly that had tentatively been set for late May. It appears certainly now that that's not going to happen. But unless we can find a way to get relief on that by executive order, that would be very high on the MSBA's list of asks in any special session to happen in 2020. And that was all I was going to say.
Thanks, Richard. I appreciate that. I didn't realize that you joined the meeting, and I'm glad that you did. I appreciate that. And if you could just keep us all apprised as you learn helpful information like that, that would be great.
And there's one more thing. I know a lot of you, most of you have seen the governor's executive order on remote notarization. We did a blog a couple of days ago that had the Secretary of State's advisory guidance on what the executive order means. Now, unfortunately, that doesn't go into a whole lot more mechanical detail either, but it is somewhat clearer than the executive order itself. And I'm going to do probably another blog on that, and I'll reference and link back to that so that people can see that on our advocacy page of the MSBA website.
Great. All right. Well, thank you, everybody. Take care, and thank you again for joining us today. Bye-bye.